Hi students! Today we can discuss on about the various case laws relating with the characteristics of company and lifting of corporate veil. Separate legal entity is a characteristic of the company, and therein we can see two major case laws or main case laws. Solomon versus Solomon and Company Limited and Lee versus Lee Air Farming Limited. These are the two case laws or two important case laws under separate legal entity characteristic of the company. Let's move on with the case law. Solomon versus Solomon and Company Limited. Solomon is a leather merchant, or Solomon carried on business as a leather merchant with himself, his wife, daughter, and 4 sons. And for 30,000 pounds, he sold his business to a company. And the purchase consideration of the sale of the business to the company was satisfied by 20,000 shares of £1 each and debentures and £10,000 debentures secured by floating charge on company's assets. That's the purchase consideration. The shareholders subscribed for 1 share of £1 each, and the shareholders subscribed 1 share of £1 each. Mr. Solomon was the managing director of the company. This is the general thread of the situation. And being the company is going on such, the company ran into difficulties and the company became insolvent and winding up commenced. At the time of winding up, the total assets amounted to £6,050. The liabilities amounted to £10,000 secured by debentures issued to Mr. Solomon. Unsecured trade creditors amounted to £8,000. Unsecured trade creditors amounted to £8,000. And unsecured, and in such a situation, the unsecured sundry creditors made a claim. Claim on what? Claim on the company's whole of the company's assets. And the unsecured sundry creditors also claim that the company is a mere agent for Solomon. And this is the background of the case. And in this case, how the judgment come? The judgment is the continuation of the trade creditors could not be mentioned. As per law, company is a distinct person from its members. The judgment says that company is distinct person from its member. The company cannot be regarded as an agent or transferee for Solomon. Secured creditors is entitled to payment out of assets in priority to unsecured creditors. Henceforth, company's assets must be applied in payment of debentures as secured creditor in priority. Only after that, unsecured creditors shall be considered. This is the judgment in Solomon versus Solomon Company Limited case. We discussed Solomon started a business. Solomon was a leather merchant and he sold his business. The purchase consideration was satisfied and the shareholders subscribed for £1 each. And the Solomon was the managing director and the managing director of the company, and this company ran into difficulties and the company got insolvent and the winding up commenced. In such a situation, and at the time of winding up, the assets amounted to £6,050 and the liabilities amounted to £10,000 secured by debentures. There is a liability secured by debentures issued to Mr. Solomon, and unsecured, and there is also unsecured trade creditors that amounted to £8,000. And in this background, the unsecured sundry creditors made a claim on whole assets of the company, and they also claimed that the company is mere alias or agent for Solomon. In such a situation, the court gave a judgment and highlighted the separate legal entity that characteristics of the company and said that as per law, company is distinct from the members and thereby the unsecured creditors' claim got invalid. The company the court said that the company cannot be regarded as just an agent of Solomon, and the unsecured creditors also claimed the whole of the company's assets. On the background of that, the judgment came out like the secured creditors is entitled to payment out of assets in priority to unsecured creditors, and henceforth the company's assets are first applied in the payment of debentures. Who are the debentures? Debentures are secured creditors, secured by debentures. Liabilities amounted to £10,000 secured by debentures. They are secured creditors. Debenture holders are secured creditors. So, secured creditors is entitled to payment out of dividends in priority to unsecured creditors. The judgment came out in such a way. Henceforth, the company's assets must be applied initially in payment of debentures, as the debentures holders are secured creditors and they are paid in priority. Only after that, the unsecured creditors shall be considered. Here, the unsecured creditors claimed the whole of the company's assets initially itself, but the judgment came out that only after the payment to the payment to the debenture holders, the secured creditors in priority, only after that unsecured creditors shall be considered. This is about Solomon versus Solomon and Company Limited, the case law. And next we can discuss about Lee versus Lee Air Farming Limited, that case law. Okay, let's start. For manufacturing of aerial top dressing, Lee Air Farming Limited was formed with share capital of £3,000. Lee Air Farming Limited was formed for manufacturing of aerial top dressing, and the share capital worth £3,000. Of this, 2,900 shares were held by Lee. Who is Lee? Lee is a qualified pilot. Lee is sole governing director of Lee Air Farming Limited. Lee is appointed as chief pilot under articles, and Lee due salary for the same. For what? For being the chief pilot under articles. In this background, while piloting the company's aircraft, Lee was killed. In the situation, Lee was getting killed while piloting the company's aircraft, and his widow claimed compensation for his death under the Workman Compensation Act. For the workers of the company were insured, and workers were entitled for compensation on death or injury. Henceforth, Lee's widow claimed compensation on his death under the Workman's Compensation Act. In that situation, the insurance company opposed the claim of the widow on the ground and pointed that Lee was not worker, for the same person could not be employer and employee. When Lee's widow claimed for compensation from the insurance company, the insurance company opposed the claim of Lee's widow and pointed that Lee is not a worker and the same person cannot be employer and employee. Regard with this, how the judgment came out. The judgment came out this way. Lee is a worker. There is a valid contract of service between Lee and the company, and henceforth Mrs. Lee or Lee's widow is entitled to get the compensation. Here the judgment came out that Lee is a worker, for there is a valid contract of service between Lee and the company, and the court made the judgment was Lee's widow or Mrs. Lee is entitled to get the compensation. Next, another property of the company is separate property. That's another characteristics of the company. And therein under the separate property characteristics, McCure versus Northern Assurance Company Limited. A case law is there. That's an important case law. McCure versus Northern Assurance Company Limited. We can discuss about that case law. There is a timber company. A timber company is there. And for the timber company, McCure is the shareholder and also a substantial creditor. McCure insured the company's timber in his own name as a shareholder and creditor. In this background, the timber of the company was destroyed in fire, and McCure claimed compensation. And the insurance company refused to compensate and contended that the company is not property of an individual. This is the background, this is the whole case. When there is a timber company and there is a timber company and McCure is a shareholder and substantial creditor, and McCure insured the company's timber in his own name as a shareholder and creditor, and the timber of the company was destroyed in fire, and McCure claimed compensation. The insurance company refused to compensate and contended that the company is not property of an individual. How the judgment came out? The judgment says that insurance company was not liable to pay compensation. Property of the company is not property of the individual. Why the judgment came such way? McCure insured the company's timber in his own name as a shareholder and creditor. The company has a separate legal entity, and company can hold properties in its own name. But here, the company's timber is insured by Lee in his own name, and the insurance company refused to compensate, saying that the company is not property of an individual. And the judgment came that the insurance company is not liable to pay compensation for the property of the company is not at all the property of an individual. The insurance company is not liable to pay compensation to McCure for the property of company is not at all the property of individual. Okay. Next, with regard to this lifting of corporate veil, we can discuss some case laws. Lifting of corporate veil is done as per Companies Act and as per judicial precedent. And therein, as per judicial precedent, protection of revenue, for the protection of revenue or for protecting the revenue, corporate veil is being lifted. Sir Dinshaw Banerjee patent. That's an important case law regard the lifting of corporate veil as per judicial precedent, and this case law is applicable when the corporate veil is lifted for the protection of revenue. Sir Dinshaw Banerjee patent. There is an SSC, and the SSC had huge income by way of dividend and interest, or the SSC is Sir Dinshaw Banerjee patent is an SSC, and he earns huge income by way of dividend and interest. What this Dinshaw did? Sir Dinshaw formed 4 private companies. In exchange of the shares, transferred his investments to each of these companies. This is actually this wealthy Sir Dinshaw did. He formed 4 private companies, and in exchange of the shares, he transferred his investments to each of these companies. And as a pretended loan, the dividends and interest income received by the company was given back to Sir Dinshaw himself. How the judgment came out? As a means of avoiding tax, the company was formed by the SSC, and company is nothing more than the SSC himself. In this situation, the court looked through the reality of the situation, lifts a corporate veil, and gives a judgment that just to avoid tax only, the company was formed by Sir Dinshaw, and company is nothing more than the SSC himself. Okay. Next, regard with the lifting of corporate veil as per judicial precedent. The another case law is for regarding the protection of fraud or improper conduct, corporate veil is being lifted. And a supporting case law, an important case law, is John versus Lipman. Johns versus Lipman. Okay, we can discuss about that case law, Johns versus Lipman. What's this case? Here, Lipman agreed to sell certain land for $5,250 to Johns. Lipman agreed to sell a certain land for $5,250 to Johns. Subsequently, Lippmann changed his mind. Lippmann sold the land to a company which was formed especially for the purpose. Being agreed to sell certain land to Johns, but subsequently Lippmann changed his mind and sold the land to the company which was formed especially for the purpose. And for this company, the company whereunto Lippmann sold the land, the company had Lippmann and a clerk of solicitors as the only members. And Johns brought an action against Lippmann and the company for the specific performance of the agreement. The judgment. The court looked the reality of the situation and ignored the transfer and said that the company should transfer the land to Johns. This is a case of Johns versus Lippmann. How the judgment come? Being when Lippmann agreed to sell, Lippmann opposed to give land to Johns he agreed to sell that for $5,000 to $50, and subsequently when Lippmann changed his mind and sold the land to a company which was formed especially for the first purpose, the Lippmann sold the land to a company which was formed especially for the purpose. Johns brought an action against Lippmann and the company for the specific performance of the sale. And how the judgment came out? The court looked to the reality of the situation and ignored the transfer made by Lippmann to the company, and the court suggested that the company should transfer the land to Johns. The next is determine enemy character of the company. For that, corporate veil is being lifted. What's the case law? Daimler Company Limited versus Continental Tire and Rubber Company Limited. Being corporate veil is being lifted as per judicial precedent in case or for to determine the enemy character of the company. And the supporting case law is Daimler Company Limited versus Continental Tire and Rubber Company Limited. Daimler Company Limited versus Continental Tire and Rubber Company Limited. Let's see the case. A company is incorporated in England. For what? For the purpose of selling tires made in Germany by German company. For the purpose of selling tires made in Germany by German company, a company was incorporated in England. And regarding this company, all directors were German residents and all shareholders were also German residents. Except one shareholder, all the shareholders are also German residents. And in the time of First World War, the English company filed suit to recover trade debt during the war between Germany and England. And this time the war between Germany and England was going on. And at the time, what the English company did? The English company filed suit to recover trade debt. And this case is referred to court, and how the judgment came out. Company was an alien enemy. Contract of selling tires made in Germany is void, and company cannot recover trade debt. Being war was going on in that situation between Germany and England, the German company being considered as an alien enemy, and contract of selling tires made in Germany henceforth becomes void, and the company cannot recover trade debt. That came out the judgment. Okay. The corporate veil is lifted being when a subsidiary to act as an agent, and when subsidiary is formed to act for the agent. The supporting case law is Merchandise Transport Limited versus British Transport Commission. Let's discuss about this case law. Herein, under which head this case law is coming? Under the head of lifting of corporate veil as per judicial precedent, being when a subsidiary is formed to act for the agent. And let's discuss case law. Merchandise Transport Limited versus British Transport Commission. A transport company wanted to obtain license for its vehicles. If it applied in its own name, it could not do so. Therefore, it formed a subsidiary company. In name of the subsidiary, the application for license was made. Vehicles were to be transferred to the subsidiary company. This is the situation. Uh, for its vehicles, a transport company wanted to obtain license. If that applies in its own name, the transport company, it could not do so. Henceforth, for it could not do so, or for it could not obtain license in its own name, the transport company applied in its own name. The transport company formed a subsidiary to obtain license for its vehicles. In the name of the subsidiary, the application of license were made, and the vehicles to be transferred to the subsidiary company, and the vehicles were to be transferred to the subsidiary company. That's the background. And with regard Merchandise Transport Limited versus British Transport Commission in this case, how the judgment come out? The parent and subsidiary were considered to be one commercial unit, and the application for license was rejected. And the application for license was rejected. Why? Being a transport company wanted to obtain license for its vehicles, and because it could not do so in its name, in that regard, actually, the parent company formed the subsidiary and made the application for license. That is a prohibited act. To do something which the parent company cannot do on regard forming a subsidiary company, that's not at all that genuine act, and in such a case also the court will lift the corporate veil. And the judgment came out that the parent and subsidiary were considered to be one commercial unit, and the application for license was rejected. Okay. Next, we can discuss on another case law. Okay, to avoid welfare legislation. To avoid welfare registration. Point under what? Being lifting of corporate veil. This is also a point under lifting of corporate veil as per judicial precedent. The case law supporting is Workman of Associated Rubber Industry Limited versus Associated Rubber Industry Limited. Okay. To avoid welfare legislation. Let's state about the case. Workman of Associated Rubber Industry Limited versus Associated Rubber Industry Limited. To use as a device to reduce the amount to be paid by way of bonus to workmen, a new company was formed. The Supreme Court upheld the piercing of the veil and looked at the real situation. A company was formed only to avoid the payment of bonus to workmen. In the case of Workman of Associated Rubber Industry Limited versus Associated Rubber Industry Limited, in that case, the Supreme Court upheld the piercing of the corporate veil and looked at the real transactions. We have now discussed some of the main case laws associated with the characteristics of the company and lifting of corporate veil. Thank you.